Laurel, this is Liz from the clerk's office. Can you hear me?
Hi.
Hi. If you want to leave your camera going so that when they're in the courtroom, the judges can see, like the court reporter, since they're going to be in the courtroom and not on Zoom, if you're able to do that.
Yes, and I've never done one this way where I was the only one on Zoom.
Yeah.
So
It will
I'm
all it will all appear here in just a minute once they turn the courtroom on. Um, but it will be they'll come up to the podium and speak so you can hear them to report. I just know if you turn your camera off on the bench, the judge can't see the court reporter. But if your camera's on, they can see you on their screen.
okay. Will I have a chance to ask who's present, or will they be giving their appearances, or how will I know who's there?
Yeah, they will give their appearances. The judge will have them do that.
Okay. All right.
And
And
it
this
and
is
if he doesn't prompt that, feel free to interject just like you did previously with asking, the parties. But typically they do have them put their appearances on for the record.
and this is Judge Yates.
Correct.
What is his first name?
It is Christopher P. Yates.
One question. Do you know what Judge
Oh, I'm here.
Redford's first name
It,
is?
it's Judge oh my gosh, James Robert Redford.
Thank you so
Yeah, of course.
much.
I'm gonna mute myself and then they'll get things rolling here in the courtroom. It looks like they're getting everything set up.
Okay,
Yeah,
wonderful.
thank
Thanks.
you.
Hear ye, hear ye, hear ye. The State Supreme Court of Claims is now in session. Presiding, the Honorable Christopher P. Yates. All persons having business herein draw near, give attention, and they shall be heard. God save these United States, the state of Michigan, and this honorable court. Please be seated.
Welcome back, everybody. Good to see you both. Let me just call the case, and then I hope we can get this done fairly quickly. I have an extremely busy afternoon, so I have to stay on schedule. This is case number 24-000041-MZ. It's the Republican National Committee and others against Jocelyn Benson in her official capacity as the Secretary of State and Jonathan Brader in his official capacity as the Director of Elections. We're here today to settle the judgment in this case. And if memory serves me correctly, we were here a couple of months ago, and then I wound up writing an opinion and order granting partial declaratory relief, which had some substance to it. It was 10 pages long, issued on June 12th of 2024. And in the conclusion, I provided not only my determination on each of the issues before the court, but I also closed by saying the court hereby invites the plaintiffs to submit a proposed judgment under MCR 2.602 paren B, close paren 3, close paren, memorializing the court's rulings and, if appropriate, closing the case. Now, my goal here, more than anything else, was just simply to give the parties the opportunity to write the judgment, because if I follow up a judgment, it can affect appellate rights and all sorts of other things. But I didn't expect that we would have too much to hash out when we got together, if we had to talk about it. It turns out that we do have some things we have to hash out, but I don't think it'll take too terribly long. The plaintiffs on June 19th, 2024, submitted a notice of presentment of proposed final order and judgment under the 7-day rule, just as I anticipated. It is 3 pages long. significantly, it includes the language I was hoping to see. Entry of this final order and judgment resolves the last pending claim and closes the case, because at some point I have to send you on to the Court of Appeals if that's where you want to go. But then it drew an objection from the defendants, who, again, quite appropriately under the court rule, submitted their own proposed final order and judgment. And what I'd like to do is just work through the concerns that seem to be animating the need for this hearing today. So, Mr. Avers, you're back on behalf of the plaintiffs.
That's right.
And Ms. Grill, you're back on behalf of the defendants. I know Ms. Meingast argued this one in the first place, but it's good to see you both. Instead of having extensive argument about this, let me just see if I can explain what I think about all this, and then maybe we can save ourselves some time. The first major issue seems to be whether there should be an injunction, permanent or otherwise, included in the judgment. And I'm kicking myself for this because I almost dropped a footnote saying that I was not going to issue injunctive relief, because in Davis versus Detroit Financial Review Team, 296 Mishap 568 at 614, a 2012 published opinion from the Court of Appeals, this court said, in talking about the propriety of injunctive relief, further, with respect to irreparable harm, we note that the Supreme Court has recently recognized that declaratory relief normally will suffice to induce the legislative and executive branches, the principal members of which have taken oaths of fealty to the Constitution identical to that taken by the judiciary, to conform their actions to constitutional requirements or confine them within constitutional limits. Only when declaratory relief has failed should the courts even begin to consider additional forms of relief in these situations. I think that clearly settles the matter. It would not be my inclination anyway in this case to issue injunctive relief, not the least of which, as Mr. Grill points out, the statute could be amended again. I mean, you hear rumblings, there may be lame duck sessions this year, who knows? So yes, Mr. Avers, go ahead. Yes, please.
What was the case again? Just for my.
Oh, I'm sorry. Davis versus Detroit Financial Review Team, 296 Mishap 568 at 614, a 2012 case. And it cites the opinion of the Michigan Supreme Court in Strauss, S-T-R-A-U-S versus Governor, 595 Mish 526 at 532, a 1999 case. And frankly, it's a sound principle. There's no way that the court should be imposing injunctions on heads of agencies or the governor or the Secretary of State unless we absolutely positively have to. And there's really nothing else to be done about it. And this is not a case where I think there has been flagrant violation to this point. So we're going to have to take the injunction language out. More interesting to me and more debatable, I guess, is the timetable that you've laid out, Mr. Avers, because I certainly concede that I didn't put any deadlines on anything, and an order without any deadlines probably doesn't make a lot of sense. But Mr. Grill, you're right. There's nothing in my opinion that says anything about deadlines. And I certainly recognize that 3 days for some things and 1 day for another thing may be too tight. We'll talk as well about whether I even should require the secretary to send something out to everybody.
If I may, Your Honor,
Sure.
I might be able to substantially abbreviate this further through correspondence with counsel yesterday and this morning. I will be able to confirm to the court today that the manual has already been amended consistent with this court's opinion, and the administrative rule has also been modified by
I'm sorry, the court reporter can't hear you.
I don't know who's speaking. I'm so sorry.
It's Mr. Grill. And why don't you start over again, because I forgot the way this courtroom works. Unless you're right at the microphone, nobody can hear anything. So assume that you didn't hear a word you said, Mr. Grill, and let's try.
100% my fault, Your Honor. I snapped back into a lower court mode. So I'm able to confirm for the court this morning that the guidance document has been modified consistent with this court's order to excise the preliminary presumption language. So that's been taken out and that has already been changed. The administrative rule has also been modified. We sent the request to the Michigan Office of Administrative Hearings and Rules.
Okay.
And they made the change so that, and as of this morning, the online version of the rule shows that there is nothing about initial presumption in that rule.
Mr. Avers, are you satisfied with those representations? You want a little time to check on it? Because if that's already been done, I don't know why I need to order it by a date certain. I still need to give you the order saying they have to do those things.
Right. So thank you, Mr. Grill. I independently verified on the Office of Administrative Hearings and Rules' website, I think is what it's called this morning. And the rule has been changed online. And so to your point, I don't think there's any need to have like a deadline to change it because it's been changed. We would ask that it still be in the order itself. I mean,
Absolutely.
Yeah. So as it pertains to the actual rule, I think we're done here on that. I also reviewed the updated manual. I mean, it seems to comply with what our request was. I will say though, as it pertains to that part of the dueling, so to speak, proposed orders, there's a more substantive difference between the secretary's order and the plaintiff's order. The plaintiff's order, proposed order.
Tell me which paragraph you're on. I'm sorry.
No,
so then I can follow along and then I'll pull theirs up too.
Yeah. So this would be the third paragraph of the plaintiff's proposed judgment.
So it is further ordered that all provisions mandating a presumption.
Yep.
That one. Okay.
Yep. And that would require that language to be excised from all of the defendant's guidance materials and not just the signature. I can't recall the exact name of the one that was, at issue here, but it was like signature verification, voter notification, something like that. The reason for that is we just don't know. I mean, the secretary has a lot of guidance materials on our website. And then let's also just keep in mind that the particular document that was at issue here was only available on the e-learning center, which of course the public can't access. You have to be a clerk to get in there. I mean, and we don't have any visibility on like what kind of training materials might be available there, so on and so forth. And so it would just seem to us that the order should direct the secretary to remove the offending language from any of those materials. We had put 3 days in. I'll be honest, that was more or less just a wild guess as to like what's reasonable, but also acknowledging that like time is of the essence here. I mean, if under MCL 168.766B, from 45 days out from an election onward, clerks do have to verify the signatures on a return envelope by the end of the next business day from receipt. And so that's been happening since June 22nd. And so we also don't want to drag our feet. Right?
Okay. Well, let me ask Mr. Grill about that, because what you say makes good sense. I'm looking at their version of it. It says it is further ordered that consistent with this court's June 12, 2024 opinion order, the defendant shall excise the phrase initial presumption of validity from the December 2023 guidance manual entitled, and if I follow your argument to its logical conclusion, Mr. Avers, they could essentially just issue the manual and call it a July 2024 manual and put the language in, and there'd be nothing that would prevent them from doing that. I'm sorry to call you back up here.
No. And I don't mean to attribute ill will. It's just like we don't have any visibility on it. And we came this far on the merits, so it would seem to us that relief would make sense.
Right. Well, Mr. Grill, anything you want to say about that? Because I don't have a problem with the language that Mr. Avers has proposed on that particular point. You'll find I'm with you on almost everything here, but not on that one.
Well, I get the point that's being raised. I guess my question would be, I mean, we've gone this far and we're at the point now of the final order. I'm a little, I guess, concerned of the idea, and I understand the idea that the concern is raising that there could be something out there that they don't know about. I'll say that I'm not aware of any other document. If there were another document that somehow referenced this document somehow and it was omitted and forgotten about, I imagine in pretty short order, we would get a phone call from Mr. Avers or somebody at their office saying this needs to be done consistent with this court's existing order, and because if nothing else, it would be misleading. This court has already ruled that the initial presumption language can't be in our guidance manual. If there is some other document out there that referenced that somehow, that order would still bind the secretary and the director to say, we have to instruct the clerks consistent with the law as interpreted by this court. I'm a little reluctant to kind of accept the pig in the poke here that, there's kind of a blanket thing that we're being told to change a document that isn't being identified in the order.
Right.
Because it kind of puts us on the hook of like, through no nefarious ill will has been said, if something were to come up later on, now we're not in front of this court on, an amended order, we're in front of this court on contempt.
But there won't be a contempt proceeding because the injunctive portion of it's coming out.
Right.
I mean, the best they could say is that you're in violation of a declaratory order.
Right, which is still not a position I'd rather have us be.
I understand.
So I think and I think at this point, this case has already existed now for at least 3 months. No one here in front of the court is able to identify any other documents. And I don't know under what circumstance that would be, if something else out there would come up that we don't know about by now.
Well, let me do this because what I'd like to do is I'd like to use your order as the draft we're going to work off, Mr. Grill, because I have some things that I'd have to take out of Mr. Avers' order. What I'm going to do is I'm going to direct that your fourth paragraph, which says it is further ordered that consistent with this court's January 12, 2024 opinion order that defendants shall excise the phrase initial presumption of validity from the December 2023 guidance manual entitled signature verification, voter notification, and signature cure be replaced with your language, Mr. Avers, which says it is further ordered that all provisions mandating a presumption of validity and signature verification of absentee ballot applications and envelopes shall be excised from all of defendants' guidance materials. Mr. Grill, you have my assurance. I am not looking to land on anybody with both feet. If something pops up that somebody in the Secretary of State's office or the Bureau of Elections didn't catch, that is not my intention at all. I think Mr. Avers is correct, though, that he prevailed on the question of whether language about presumption of validity could be included in anything. And so I need to give him an order that reflects that ruling. Okay. All right. Now, I didn't see anything else that troubled me in terms of the differences between the orders. Obviously, they're worded a little bit differently, but Mr. Avers, since we're going to use theirs as the basis for the order, but we're putting your language in for that paragraph, is there anything else that you think from your order should be included?
Yes.
Okay, tell me what you want, because I'm not opposed to adding more.
So given that the plaintiffs sought and were awarded a declaratory judgment, it would seem to me that paragraphs 2 and 6 from the plaintiff's order should be in the final order and judgment. And those are just the actual declarations coming from the court. And that would be consistent if you were to look at page 7 of the court's opinion. Right. It does say, accordingly, the court shall award a declaratory judgment describing as impermissible all presumption language contained in the guidance manual for dealing with absentee ballot applications and envelopes.
All right. And so you're not satisfied that their second paragraph, for example, covers that in the same way that your second paragraph does. Yours says it is hereby declared that under MCR 2.605 that the initial presumption of validity and signature verification of absentee ballot applications and envelopes mandated by the December 2023 guidance manual issued by defendants is incompatible with the constitutional laws of the state of Michigan.
It's just my understanding under the rule that it would have to be in there. And
right. Okay. That's fine. That's fine. Let me just see how best to put that in there. So I think what I would do is do you want it above or below their second paragraph? Your second paragraph inserted above or below their second paragraph. How does it flow better?
One moment.
Because I certainly, Mr. Gill, this is one where I don't have any qualms at all about it in English language because it's exactly what I said.
I guess my concern, Your Honor, and this was something we articulated in our brief. I guess I'm not certain of the court rule Mr. Avers is citing. I would like to know what the obligation is to have the declared language separate and apart from this court's already entered written opinion and order saying exactly that. It is declared as follows. My concern, and as we expressed in the brief, is that we're starting to pick and choose the parts of what the court's previous written opinion that are being now reduced to this order, and it is incomplete insofar as it declares they win as to, the initial presumption and as to the catch line of the rule, but somehow the part about it, the rule being constitutionally valid doesn't make it into this final order.
Well, you can put that in there if you want as well.
The goal I had in my language was just for the reasons stated in this court's prior written order, and that order, I think, did a better job that either Mr. Avers or I could do to express this court's order.
Let me put it this way. I appreciate what you're saying, and I would much rather issue a shorter judgment than a longer judgment. But it seems to me that if each one of you wants language in the judgment saying, as a matter of declaratory relief, you won on what you won on, I don't have any qualms about putting that in. I hear what you're saying, because it seems patently obvious to me from my opinion and order what happened.
Well, like I say, my concern is the more we do that, the opportunity then is for either through mistake or through mischief, something gets added or modified in this order that somehow doesn't quite reflect what was in the earlier order, which is why I much prefer the for the reasons already stated language, because it's already stated.
Right. All right. Mr. Avers, you want to come back up here? As I say, I can't stand it when a judgment gets longer than it has to be. This one doesn't need to go on and on and on. But on the other hand, it's very clear from the last paragraph, in my opinion, what I said about what you won on and what I said about what they won on.
Yeah, I mean, my recollection from drafting is I copy and pasted the declarations from the opinion into the order. And so I honestly don't see a whole lot of appetite for mischief here. I think if it's a declaratory judgment, it's got to be in the judgment. Otherwise I think there is an opportunity for mischief because you could say, okay, well, the declarations are in the opinion, and now I'm picking and choosing information, words out of the opinion, right?
Right. And as crazy as it may seem, your hyper-technical approach to this, I think, is exactly what I think, that if each one of you won on issues, if you want that language reflected in the judgment, you may have it. So what I'm going to do is this. I'm going to ask you in a minute if we have anything else, but what I'd like you to do, Mr. Avers, is when we get out of here today, to take their order, substitute the paragraph that I said you could substitute, and then put in one paragraph declaring you the winner on anything you want to be declared the winner on. And then, Mr. Grill, behind that, you put in a paragraph declaring yourself to be the winner on whatever you want to be the winner on.
Clarify the court's order, then the court's directive is that council should confer with each other and submit one order to this court that we both stipulate to the form of consistent with today's ruling.
Yes, by tomorrow at 5 o'clock, please. We need to get this thing entered. Look, you are both fantastic lawyers. I have no doubt that if we talk through this, you'll know what I want you to do. But what I'm telling you right now is we're substituting your paragraph 3
For their 4.
Mr. Avers, for their paragraph 4. You get a paragraph that can be exactly or nearly exactly like your paragraph 2. And Mr. Grill, you get a paragraph right behind that that can be exactly or nearly exactly what I said on the issues where I ruled in favor of your clients. Okay, if we do that, are we finished?
I think that the only remaining issue is whether there should be some kind of a communication to local clerks.
Oh, I have a feeling you opposed that, Mr. Grill.
Well, again, it wasn't in the written.
Right.
Your Honor, it was not part of the court's written opinion and order. I will also represent to the court that the clerks have been informed of the modifications to the manual already. I don't think we need to kind of spend a lot of time on this other than to say, I don't think we need to add new requirements or new conditions that weren't included in this court's order, or I think specifically spelled out in the complaint.
Yeah, let me put it this way, Mr. Avers. I'm not going to order that because I wasn't asked to order that in the first place, but I would certainly hope and expect that they would send a directive out, making it very clear. And beyond that, I think it would be dangerous not to send a directive out saying that you can't do that, because you know how this language hangs around.
I mean, these are PDF documents. People print these documents.
I know.
They leave them on their desk.
Right.
I have them on my desk. I have them saved on my desktop. When the secretary revises these documents, she doesn't issue a red line saying that this change was made for these reasons. It's just, there's suddenly a new document, right? And so to my mind, I think it'd be very appropriate in order for a simple communication to go out to them.
Right, I'm not disagreeing with you in principle. The only thing that makes me nervous about it is we were trying to take an opinion in order and reduce it to a judgment.
I understand that. I mean, I'm looking at MCR 2.605F, which gives the court the opportunity after reasonable notice and hearing to award further necessary and proper relief to effectuate its judgment. And that's all that this is. I mean, we have an election that's happening right now. They're verifying signatures right now.
I understand.
And there's, more than 1,000 local jurisdictions and clerks across the state that have to practically apply what happened here. And, it does not seem at all unreasonable to me. And it seems actually quite likely to me that there is a clerk out there now that has a hard copy of this document somewhere, and it's the December 2023 document and not the July 2024 document. For what it's worth, the secretary issues updates to clerks a lot when things change, whether it's an amendment or something like that. This is not a unique, it would not at all be unique for the secretary to reach out to clerks and say, hey, this happened.
Right.
Here's an updated guidance material, and make sure that you direct the appropriate personnel in your jurisdiction to not apply a presumption of validity to signatures.
Well, and I hate to make you keep moving to and from the lectern, but Mr. Grill, let me just ask you, you said that something's been sent out already on this?
Yes. The notification went out last week, I believe. I don't want to name a date because I'll be wrong, but it went out last week. There has already been a notification to clerks of this change having occurred. I am worried about.
Can you send that to Mr. Avers and me at the end of this hearing so we can see what it said? Because I don't want to order something that's already been done. But on the other hand, he's right. The 2.605 does contemplate additional relief. And this is the sort of thing I might seriously consider. But if it's been done, there's no point in putting it in the judgment.
I believe that it has been done, Your Honor. I also I'm loath to wander down this track because I have, not before this court, but I've been in other circumstances where there's an ordered communication, and then we get into the language of the communication and the wordsmithing of how it's worded and what it's including and to whom it goes and at what time and when. I think I understand what Mr. Avers is saying. I don't necessarily. We have an interest in administering elections as well. We don't want clerks operating off of old rules, so there is every reason in the world for our office to make sure that clerks are informed of and apply the correct standards of law.
Right, Mr. Grill, that's why I want to see it too, because if it effectively communicates what Mr. Avers wants communicated, I'm not going to let him dictate what the notice says. I just want to see it. And if in fact it provides the sum and substance of what I said in my opinion, I'll be fine with it. And there's no reason to say anything about it in the judgment.
I will, when I return to my office, I will send a correspondence. I believe there has been some email traffic in the efforts to schedule this hearing. I can just reply to that last thread, which I believe will go to Mr. Avers and his co-counsel. And then I don't believe it goes to you directly, Your Honor. I believe it goes to Ms. House. I'm sorry, I forgot her name, Victoria.
Oh, Howenstein.
Howenstein.
That's fine. Yeah, well, Mr. Avers, you have my assurance. I'm going to look at it too. And as long as it accomplishes what I think you and I both think it needs to accomplish, I'm not going to put any language in the judgment. But if it turns out to be so vanilla and nondescript as to not even explain what's being done, then of course, please come back and ask for relief and I'll give it to you.
Not trying to make a mountain out of a molehill here, but remember the presumption was applied during the presidential primary in February. And so this is a change, right? And it's an important one. And so just to be clear, if the communication, is not, for lack of a better word, sufficient from our perspective, is it just an objection under the 7-day rule, or how would you like us to?
Let's get the judgment entered, and if you want to file a motion for post-judgment relief, I'll be glad to take it up. But that doesn't seem to me to be an issue on which this appeal should concern itself, unless I'm missing something here.
I mean, just to me, time is of the essence here, right? I mean, and that goes to the communication too. I mean, there's clerks reviewing signatures right now. Right.
Mr. Avers, I will get to it by the end of this week if you ask for additional relief. I'm off in August. I'm doing nothing but court of claims for the next couple of weeks. So I promise you, I mean, if we have to turn this around in 24 hours, if there's one thing I've learned, and Mr. Grill's been part of my learning process, I need to get these decisions out right away. So I'm very sympathetic.
Okay, understood. Thanks, Judge.
Okay.
You're on it. recognize the court has a schedule. I just do want to also note, if this had been brought to our attention in the form of a response brief, I could have had that communication with me this afternoon.
I got it. Look, I'm not going to blame either one of you for anything. You two have revealed yourselves to be fantastic lawyers, not just in this case, but across all the election disputes that we have. And I wish over the course of my career, I'd had only lawyers of your caliber in front of me. It would have been a really easy time the last 16 years being a judge. But Mr. Avers, you don't have to respond to this, but I understand. I've worked in lots of government agencies and I know how things hang around. And I've seen lots of situations where people are citing standards of review because they're pulling them from old briefs and there's a brand new Supreme Court case that says something different. So you don't have to comment on that, but I'm well aware of it. If you don't like what they sent out and you think it's not descriptive enough, file something and I'll take it up. And I promise you'll get an answer by the end of the week. Okay. All right. Thank you both. And then if you get the judgment to me tomorrow, which I'm ordering you to do by 5 o'clock tomorrow, I'll promise I'll sign it and get it entered. So if anybody wants to go to the Court of Appeals, I don't want to hold you up. I know time is truly of the essence now. Thank you. Okay. Thanks, everybody. Really appreciate it. Okay. Let's move on to the 1:30. Is Turnpaw against the Michigan Department of Corrections. So let me get this out of the way.
I'm sorry, could I have 30 seconds to split the
Yes.
file?